By now, you should be familiar with the basic facts and the litigation history of the Plomp case, in which Hendrikus Plomp seemed to be unaware that a person can be charged and convicted with an offence purely on the basis of circumstantial evidence. And you can see that reflected in these three quotes attributed to Plomp by various witnesses at his murder trial. He told one fellow bus driver, for example, "You're tied to your old woman's apron strings. You ought to take her for a swim." And he told another driver that drowning was basically a foolproof way of getting away with murder. He told him, "That's the easy way to get rid of your wife. There's no sign of violence and it's your word against theirs." And when he tried to marry his mistress 2 days after his wife died, the minister told Plomp that he wouldn't conduct the wedding until the coronial inquest into the wife's death was over. And Plomp replied that, "I'm not concerned about the inquest. They can say what they like. The police are perfectly satisfied that the drowning was accidental. I am the only witness to the drowning, and if I claim privilege and refuse to give evidence, that's the end of the inquest." Well, of course, that's a nice Hollywood-style theory, but it's completely wrong at law. The law's a bit more complicated than that, as both Mr. and Mrs. Plomp unfortunately found out. In this slideshow, we'll flesh out some of the legal and factual details related to the Plomp prosecution and the special leave application to try and help you avoid some rookie errors of your own in reading and understanding judgments and other reports in criminal cases. So what is circumstantial evidence? Well, let's consider a simple fact scenario. Let's suppose I come home one day to find muddy little shoe prints in a line across my living room carpet. As you can see here, that's an offence pursuant to the relevant offence creating provision, which is section 123 of the Prohibited Domestic Activities Act 2015. The Act provides that any person who walks across my carpet in muddy shoes commits an offence. And so the three elements of that offence are any person, walks across the carpet, muddy shoes. Now, based on my observation of those muddy shoe prints, I infer that my 10-year-old has come in the house with her shoes on. I didn't directly see her, but I see the imprint of her shoes, so I use the fact that her shoes were there as an inference that she was there. And that's all circumstantial evidence is, using one fact as evidence of another fact. It's not direct evidence of the alleged fact that my daughter wore her shoes in the house, because it's not a direct observation that I, as a witness, made, or a recording of her walking on the carpet. She made the same critical error, though, as Mr. Plomp, in assuming that if nobody saw her there, then she could just remain silent and there would be no proof that she was there. Direct evidence of the alleged offence could be something like eyewitness testimony from my wife saying, "I saw her walk across the carpet in her muddy shoes," or maybe CCTV footage from something like a nanny cam of the child walking across the carpet in her muddy shoes. Obviously, not every crime is seen or heard by a witness or recorded. Obviously, not every crime is seen or heard by a witness or recorded or confessed to. So in virtually every trial, the party bearing the onus of proof will have to rely on some evidence about the surrounding circumstances. And in a criminal trial, the party bearing the onus of proof will be the prosecution. In fact, in as many as 1 in 5 homicide cases dealt with by Queensland courts, the body of the person who's presumed to be deceased is never found, or if it is found, nobody saw or heard the events which caused the death. But neither the criminal law nor the civil law of Queensland requires the finding of a corpse in order to deem that a particular person's dead. Once a person's been missing without explanation for a period of time, the coroner will usually be asked to hold an inquest, and then the person can be deemed to be deceased. Death certificates can be issued, civil courts will allow the person's estate to be distributed according to their will, and police can indict a suspect for murder or manslaughter. Sometimes there will be a body found, as was the case with Faye Plomp, but there won't be any direct evidence linking anyone to the death. Many people who kill another person, of course, take some trouble to try and cover up their involvement. Although most homicides are committed as an act of passion on the spur of the moment, some of them are planned. But often investigators can gather evidence of the circumstances surrounding the disappearance or the death. There may be evidence of motive on the part of the accused, for example, as was the case with Mr. Plomp wanting to marry his mistress, or there might be evidence of opportunity. And of course, Mr. Plomp had ample opportunity to kill without being seen, given that the drowning of his wife occurred at dusk on a part of Main Beach that was deserted at the time. And remember, from your reading of the case, he said to police that it was his wife who wanted to go for just one last swim at the beach at the end of the day before driving back up to Inala, where they lived with the children. And if there's enough of this sort of evidence to convince a jury that the only rational explanation for the existence of these circumstances is that the accused person caused the death of their deceased, then they'll be convicted of manslaughter. If the Crown can convince the jury that the accused also intended the death to occur, then the accused will be convicted of the more serious offence of murder. Plomp killed his wife on the 24th of February 1961. He was 31 years of age and she was 23. We don't read about it in the High Court decision, of course, but after his wife had died and while he was waiting for the murder trial to come to court, he was charged, convicted and imprisoned for the rape of a young Italian woman in St. Lucia. And that conviction was overturned by the Court of Appeal before he went to trial for the murder. His 1962 Court of Criminal Appeal of the murder conviction was unsuccessful, as was his special leave application, as we know, to the High Court in October of 63. He served 12 years in Boggo Road Prison and at Numinbah Prison Farm before he was eligible to apply for parole, which he successfully did. He was deported back to Holland in 1972, aged 42. So still with quite a bit of his life in front of him. He was a Dutch citizen and he'd never been naturalised. But shortly after he arrived in Holland, he moved to Canada, where his parents had taken the children after he was imprisoned and after Faye had died. So today he'd be 85 years of age. His story about his heroic efforts to save her in the surf and his feigned grief didn't really convince anyone from the start. The suspicious circumstances were just too many and they were too damning. But that probably illustrates, as we said before, how convinced he was that he'd be safe from prosecution if there were no witnesses and if he didn't give evidence in court. In fact, he was quite cheerful and chatty during the committal hearing, and he reportedly said to journalists at that hearing, "I bet I'm the calmest man in Brisbane right now. I've got no butterflies or nerves or anything. I know I'm going to get out of this." And so the Plomp case has been compared to the much more recent Baden Clay murder, a lot of things in common in Brisbane, in which deep suspicion fell on the husband almost straight away with all sorts of suspicious circumstances. And that, of course, was a wholly circumstantial case as well. Plomp had a mistress. He tried to access the money from Faye's insurance policy an hour before her funeral. He and his new lover applied for a marriage licence on the day of the funeral, and police came to, I think, arrest him then. He told different versions of what happened at the beach to different people. He had scratches on his body, which he didn't have a believable explanation for, claiming he got them while wrestling with his neighbour's dog. His story that Faye insisted on swimming at 6:30 p.m. at night and on leaving their toddler locked in the car didn't ring true for people who knew Faye. She was 4 months pregnant, for one thing. She was very protective of the young boy, and she was known to be a very good swimmer. And the surf, which Plomp said had drowned her, was described by lifesavers who'd been on duty earlier in the day as very calm. So it was circumstantial evidence of opportunity that the incident occurred when the lifesavers had already left. And he also had a history of domestic violence. There were prior statements made to the fellow bus drivers, which it turned out were made after he'd actually been fighting with Faye. His mistress, who moved in with him after the killing, gave evidence that Plomp had told her he was already a widower and that he'd introduced the 4-year-old son to her a few weeks before Faye's death as your new mummy, and he was also physically abusive to the new mistress. The jury took only 85 minutes to convict Plomp for murder, so we can assume that they were satisfied beyond reasonable doubt that Plomp had intentionally killed his wife. One ground of the High Court appeal, as you will know, or of the special leave application, was that the trial judge allegedly confused the jury by conflating two different rules. The one which says that a jury must be persuaded beyond reasonable doubt to bring down a guilty verdict, and the one for wholly circumstantial cases which says that they need to be satisfied that the guilt of the accused is the only rational inference they can draw from the circumstantial evidence considered as a whole. And of course the High Court just said that those statements describe generally the same standard, that the circumstantial test is a specific example of how the more general beyond reasonable doubt standard might be reached. These days, that's made perfectly clear for judges and juries by the relevant entry in the Supreme Court bench book, which you can see extracted here. And by the way, that bench book, you can find, I think, PDF copies of the various chapters at that URL. Is quite useful to look at when you're seeing how judges sum up the elements of particular offences for juries. It's not an authoritative source to quote, but it will usually contain the common law authorities on which the principles are based. And notice, especially for our purposes, and this is what I want to highlight for you, that the authority cited here for the test in relation to circumstantial evidence is not Plomp, the test which specifies the only rational inference. So I wonder why that is, given that we had basically the full High Court bench in Plomp considering just what the test was. Why isn't it cited as the authority, as the binding ratio? Well, it's because the Plomp High Court matter was not a case at all. It was a judicial appeal of the it wasn't a judicial appeal of the Court of Criminal Appeal decision. It was a special leave hearing. In other words, it was an administrative hearing where the High Court judges could figure out if there was any new principle of law to be decided on the basis of any appeal, or whether it just involved an application of existing law. So what is an application for special leave? A convicted person who unsuccessfully appeals a criminal conviction to a state appellate court has no right of appeal to the High Court. But they do have a right to apply for something called special leave to appeal. And that just means that some High Court judges will hear from the appellant's lawyers what their proposed grounds of appeal would be if leave to appeal were granted. And if those grounds are strong and they involve an uncertain area of law that the High Court believes as a matter of public interest need to be settled, then the court may well decide to grant leave to appeal and go ahead and hear a full appeal of the matter. But if and until special leave to appeal is granted, there's no proceeding on foot between the parties. No proceeding which enlivens the court's jurisdiction to make a determination of law. You get the idea? A special leave application is an administrative function which involves some legal argument. The court isn't convened to hear and decide on an appeal because it hasn't even decided yet if an appeal will go ahead. All right, so it's a little bit like a committal proceeding at first instance. And so that means that in Plomp's case, there was literally no matter engaging the court's jurisdiction to make a determination other than the administrative decision that they wouldn't bother going ahead with an appeal. So, crucially important, Plomp is not a binding authority for any point of law because it was simply an application for special leave which was rejected. And you'll find that here's an extract from the report itself. Application for special leave to appeal from the Supreme Court of Queensland. All right, and that would flag for you that whatever is happening in this report will not be cited as binding authority. What it does do is explains, in this case, and restates existing legal principles in the context of the Plomp facts. But the authorities for those principles come from previous common law decisions. So you could see, for example, when you have a look back at the case, at the report, where Chief Justice Dixon and Plomp cites a 1936 decision of Martin and Osborne to explain what the relevant test for a jury in determining a wholly circumstantial case is. Now, in this unit, we don't expect you to know the intricate details of how special leave applications work, and you're not going to get complex exam questions where you get tricked into thinking that a special leave application is really a full appeal. That wasn't the point of this exercise. But it's when you see things like that on a report, it's a cautionary example of why you need to forensically and analytically read the cases that you're studying and that you're seeking to apply. Don't just read head notes, don't just flick through. Look very carefully at them. If you wanted to cite an actual authority for the test for circumstantial evidence in Queensland, then you'd cite Shepherd, just as the bench book does. Finally, something for you to think about. The evidence against, the circumstantial evidence against Plomp was fairly overwhelming against Mr. Plomp. But is it possible that Faye Plomp might have died in the way that Mr. Plomp asserted? In other words, is it possible that she really did just get sucked into the surf and drown without any intervention by him? Is the explanation that he intentionally killed Faye, is that the only rational explanation for the circumstances? Or is an explanation that she just drowned, is that rational? Is the explanation that she drowned a reasonable explanation? Is the explanation that he killed her a reasonable explanation? Remember to look at facts and arguments and rules from both the perspective of the Crown and the defence when you're reading criminal cases.